Hello, I'm Molly at Park Walsh, a licensed insolvency practitioner. So I'm going to be discussing whether or not a liquidation can affect the director's credit rating. I do get asked that question a lot. So essentially, when you liquidate a limited company, that is a separate legal entity to the director. However, that liquidation is public record. It's recorded on Companies House and in the London Gazette. So it can't be kept hidden. So certain institutions, banks, etc., will be able to find that information if they look for it. But you have to remember, as I've said, a limited company is a separate legal entity to the director. And it would also depend on the situation of the liquidation as to whether or not that does affect the director's credit rating. For example, if you've given personal guarantees to some of the creditors and enter into a repayment plan, or if there's an overdrawn director's loan account, essentially that's where you owe money to the company. These things can affect the director's credit rating. We had one situation recently where a director had put his company into liquidation and then he was looking to move and he applied for a mortgage. The bank did find out about the liquidation, but it wasn't an issue because the mortgage wasn't based on the director's income from that limited company. So although they were aware of it, it didn't affect anything. So in answer to whether or not it affects the credit rating, it will all depend on the situation. It will affect obviously the company's credit rating, and I'm presuming in this scenario with the liquidation the company would have ceased trading, so it doesn't particularly matter. It can affect the director's credit rating if there is an overdrawn director's loan account that the director couldn't repay, or personal guarantees and it struggled to repay it or had to enter into a repayment plan. So those factors can affect it. But if you want to discuss it and it's maybe putting you off putting your company into liquidation, which isn't the best idea, you always need to take action with your limited company if it does need it. But sometimes that can be a factor as to stopping you from taking advice. But what I'd suggest is to get in touch with someone like myself, a licensed insolvency practitioner, and we'll be able to run through your queries and what you're worried about and see how it affects that, and we can find a solution that suits the limited company and you. Okay, I hope that's helped. Thank you.